Welcome back to the show. So tonight we will be reflecting on the big case that was decided by the Supreme Court in the matter of Assin North. But that's not the only thing we'll be talking about. There are lots of issues around dual citizenship that need to be looked at, and also the question of constitutional review. Professor Kweku Asare, affectionately called Kweku Azar, is my guest. Welcome to the show.
Thank you so much. Good evening, Bernard, and thank you for having me here once again.
I was fascinated to find out that you have been trying to get public policy positions articulated on important Ghanaian issues for over 2.5 decades. And apparently, whilst I was in my first year, you were already taking on MPs for taking car loans, you were petitioning Shraj, and all of this. But you're not even a lawyer. Where from this spirit of that you have been exhibiting for over 2.5 decades?
Well, you know, it goes way back to even secondary school days. In our secondary school days, we lived under the military government. Okay. And so we learned a couple of things about liberty, equality, fraternity. I did A-level history, European history, from 1789 to 1919, which is the First World War. And, you know, when you read history at that time, you learn a lot about the importance of civil liberty, political liberty, and so on. So, yes, I've been in the trenches for a very long time. I was part of the group of students that Chairman Rawlings, then of the PNDC, sent workers, Obuasi mine workers, to come and attack us. We're having a student meeting then at KNUST, what you guys call KNUST these days. In those days, it was just UST. So we did that as students, and then we didn't stop when we graduated. And so the Shraj case that you alluded to, I think, was something that happened maybe in 2002. But even before then, we had lobbied for the law to be changed, Act 527, that allowed dual citizenship. I was part of the lobby group that got that change to happen.
Wow. So this was in the mid-90s where you felt that the constitution which precluded dual, in fact, which didn't even have contemplation of dual citizenship, was not right. So we needed to amend it.
Yeah, absolutely.
And this was under Rawlings.
This was under Rawlings, the first parliament.
And they agreed with you?
They agreed. That's why we have dual citizenship today. Act 527, when you look at the constitution today that you have, Article 8.1 says a citizen of Ghana can be a citizen of another country.
It was never like that.
Yes, it was never like that. And we said to them, why? Because one thing about Ghana is that we do things without analyzing the law in its full perspective. Yeah. Because if somebody was a citizen, upon coming into the force of the Constitution, the Constitution cannot retrospectively take away his citizenship because of the person having another citizenship. Anyway, it was very easy to convince that first parliament that, look, the cardinal sin of that 1992 constitution was the citizenship. It got it wrong, and they understood and they fixed it.
So that was Act 527. But later on, they would make an amendment in Act 591, which then precluded some dual citizens from occupying some positions, which matter you later on challenged because you felt that Act 591, which said that for some positions you couldn't be a dual citizen and hold, it was unconstitutional, it was a violation of their rights. You didn't really succeed with that.
Yeah, well, that was a complex case because that's part of the argument. Because you see, Act 527 excluded dual citizens from holding some specific positions.
Yes.
Now, a line in Act 527 said Parliament can add more offices. And then a second line said the minister can also add more offices. So when I went to the court, I was arguing that there are a couple of problems. Number one, I don't even believe Parliament can take political rights away from citizens. Second, I don't even believe that the minister can take political rights away from citizens. And third, I don't think a dual citizen must be compelled to carry a dual citizenship card. So those were the three things that we argued about in that case. And the court agreed with me with respect to the card. The court agreed with me with respect to the minister adding positions. They disagreed with me with respect to Parliament adding positions. Therefore, Section 16.2 of the Citizenship Act was saved. But Justice Akufu and Justice Owusu, the women on the panel, agreed with me. And they said, look, citizenship has to mean something. And so when you say somebody is a citizen and you start scrapping away from that, taking political rights away from them, it has to be something that you do only through a constitutional amendment. And so even though they dissented, I think they got it right.
So this is Asari versus Attorney General 2012.
This Asari versus Attorney General 2012 has nothing to do with Article 94(2).
Of course, it was cited in the judgment, page 26, where they used it, and I'll come to that. I'm just trying to get a quick history on this. So, the Act 527, you were part of the team. The Asari versus Attorney General 2012 was something that you led. Yes. But I was just reading through some of the cases you had sent to Supreme Court. And viewers, he is not a lawyer, which is quite interesting. So you studied admin at Legon.
Well, I studied admin at Legon and then went on to do a PhD in accounting.
A PhD in accounting?
Yes. And then in 2006, I actually became a lawyer.
Okay, this is in the US?
In the US, yes.
So you did an LLB or JD?
I did a JD.
I see. So were you called to the bar?
I was called to the Florida bar, yes.
Wonderful. But you didn't try to be called to the bar in Ghana?
No, because I had left Ghana.
I see. But there are people who come and do what they call the post call and come and become lawyers in Ghana to practice. Did you do that?
No, because obviously I don't live here.
You don't live in Ghana.
And if I lived here as a matter of principle, I wouldn't do it because I don't believe that the Ghana School of Law is a constitutional creature. I think they have done that unconstitutionally.
Really?
And I challenge that Article 25(2) case.
Yes, it's one of the cases I was going to make reference to.
And that's the funniest case that you can read. The court said it has no jurisdiction to hear that case.
Why?
Because they said...
This is the Supreme Court.
This is the Supreme Court.
Yeah, and in that case, you were trying to say that for a qualified lawyer from any jurisdiction doesn't need to be prescribed from practicing here? Is that what you said?
No. I was saying that Article 25(2).
Yes,
if you read Article 25(2), it says the state...
Let me read it. All persons shall have the rights to equal, 25(1), shall have the rights to equal educational opportunities and facilities, and with a view to achieving the full realization of that right. That's 1. And then it gives basic things. 2. Every person shall have the right at his own expense to establish and maintain a private school or schools at all levels, and of such categories and in accordance with such conditions as may be provided by law.
Precisely. So everyone can set up a school as long as he meets whatever criteria the state comes up with, at all levels.
So Ghana School of Law cannot be the only law school?
Precisely. Ghana School of Law cannot be the only school of law. And they said, well, we're not going to decide it because we have no jurisdiction.
How come?
That's just one of those.
It's not an interpretation issue?
It is an interpretation and an enforcement issue because I believe the General Legal Council has created this creature, which is unconstitutional. And yet, the Supreme Court would not even go into the merits of the case. That was a disgraceful...
Did you go under the original jurisdiction, or did you...
I went under 2-1 because I said the Constitution was being violated.
Enforcement. So
yes,
so
I wanted an enforcement
of Article 25(2). Precisely. And the Supreme Court said they didn't agree with you.
They didn't even go into the merits, because if they went into the merits, I was going to win.
So if they said you didn't have, did they say you should go to another court?
Well, which court can hear it? Because if I go to the court and I say the Constitution is being violated.
No, I'm asking because if, for example, I have an election problem, it's very clear I have to go to a high court, and that it terminates at the Court of Appeal. So I could go to Supreme Court with an election petition disguised as an interpretation matter, and they can say we don't have jurisdiction. So if you go with 25(2) that they should enforce the Constitution, and they say they don't have jurisdiction, are they saying that then the issue is not justiciable? Is that what they are saying?
I don't understand what they are saying. I mean, all I know is whatever they are saying doesn't make any sense.
Right, since they are not here to defend themselves, I just wanted to show you some of the cases that Kweku Azar had taken, the ones that come to mind. So there was an original, so Asari versus AG, they are many. So if you don't put the year or the specific descriptor, you'll get confused. So the Asari versus AG 2012 was in relation to Act 591. But the Asari versus AG, the original speaker case, Asai versus AG, dual citizenship. Asai versus AG, Constitutional Review Commission case. Then Asai versus General Legal Council, which is law exams and entrance. Then there's Asai versus GLC, this is 25-2 you spoke about, which the Supreme Court said they didn't have jurisdiction. Asai versus AG, Speaker 2, the Joe Ajaho one. That one I remember Samens was involved as well. So that was a consolidated case. And I think you won.
Yes.
You won 9-0.
Yeah.
Then there was High Court cases. So just to clarify, the original Asai versus AG Speaker case was what?
The original case was the question of whether when the president and vice president are away from the country, somebody has to be sworn in to act as president.
Good.
And my understanding of the Constitution was that no. In fact, I believe the court misapplied the 1969 Constitution.
Okay.
Because in the 1969 Constitution, when the prime minister was away, or the president was away, then the speaker would act. But that made sense because we had a cabinet style of government, a Westminster type of government, where the president, the prime minister, and the speaker were from the same party. But when we transitioned to a presidential type of arrangement in 1992, it created a conundrum where if the president and the vice president were away, you could have a speaker who was from a different party, like we have now.
Okay.
And as you can see now, the president and the vice president, they hardly travel together because probably they don't want to swear in Speaker Bagman. And then the first executive action taken by Speaker Bagman is, I've declared the president and the vice president persona non grata. They shouldn't come back to Ghana. Then we have a big crisis.
That is possible, but is that probable?
Why not? You see, that is why we don't play with the law. Because the law thinks about the funniest thing that can happen and stops it.
So your contention in that case was that we didn't need to swear in the speaker?
My contention was that the Constitution did not say we should swear in the speaker. The Constitution said if the president and vice president are unable to perform their functions, then we swear in a speaker. But if your president is at the United Nations,
He's performing his functions.
he's performing his functions. If there's a vice president, then I think it was Ali Umar. He was in Saudi Arabia performing another national assignment. So what is the reason
For swearing in somebody
the
else?
speaker when these people are
So
out
this was
there?
during Kufuor time?
This was the first time, yes.
I see. The CRC case was when?
The CRC case was, I think, 2011 or 2012, but it was decided in 2015.
Wow.
And this is when President Mills appointed the Constitutional Review Commission to review the Constitution and come up with bills to amend the Constitution.
Yeah.
And I said, well, what is the source of the power for that? The Constitution is very clear on how it should be amended. It is only Parliament that is given the power to amend the Constitution. In fact, the only time the president comes in when it comes to constitutional amendment is at the tail end to give the assent. And even that assent is mandatory. He can't say...
So you can't initiate the process?
No. And the reason is very clear. Because all the problems in the world...
Presidents trying to change constitution.
Presidents trying to change the constitution.
So, but the Supreme Court disagree with you?
The Supreme Court, of course, they always agree with the person who has power, the president. Although, I think everybody should read the dissent. The dissent in that case, there are two of them. One by Justice Doche, and then the other by Justice Ani Yeboah. I think the dissent, they were very powerful dissent.
Which is funny because Ani Yeboah just handed over as CG, I think a few weeks ago, and Doche also just retired.
Yes.
So they supported your view?
Yes, they supported, and they said this is very clear. And incidentally, the same thing has happened in Kenya. The Kenya president initiated, they have what we call the popular initiative, where if you gather a certain number of signatures, you can amend the constitution. But the Kenya president initiated the signature gathering process. They gathered about 5 million signatures. And somebody took it to the Supreme Court. The Supreme Court said, yes, this is unconstitutional because the president should not have any role in amending the constitution. The Kenyan Supreme Court got it right. I think our Supreme Court got it very
then
wrong.
Your Asari versus GLC, the original one was on law exams and entrance. You were saying that there was no need to have an entrance exam into the law school.
Absolutely. And the court agreed with me, because there was actually an instrument, a legislative instrument in place at that time. And that legislative instrument did not contemplate either an entrance exam or an interview. And so the court said, yeah, what you are doing is unconstitutional. But you see, the funny thing, even when they said what you were doing is unconstitutional, they still allowed the General Legal Counsel to go ahead and administer the exam. So that is the way in which I think our Supreme Court sometimes plays with our Constitution, because they are not reading and enforcing the Constitution the way it's supposed to be enforced.
So what do you think of the Demolovo case, where people say the horse has already bolted? They declare the president's actions in essentially forcing Mr. Demolovo to go and leave as unconstitutional, but the man's leave had already been enforced in a way. So is it one of the ways in which you see the Supreme Court as not helping itself?
Absolutely, because remember, let's say somebody is facing the death sentence on June 30th, and he goes to the Supreme Court on June 15th, and he says, hey, I want you to hear the case, the tri-court heard, and so on. And the Supreme Court doesn't hear the case, but the guy is executed on June 30th. What will be the point of coming to tell us next year
that execution was unlawful?
Precisely. It's completely useless. Now, I was a party. In fact, I initiated the first lawsuit in the Demolovo case. And I was stunned, because I asked for an injunction. Not only did they deny the injunction, on the very date that I was asking for the injunction, the Deputy Auditor General, who I was claiming was occupying the Auditor General's position unconstitutionally, was in court, in the Supreme Court, and they were hearing from him.
On a different matter?
On a different matter. Right there, I knew I was wasting my time. And so I ended up withdrawing my case, because I felt this court is not serious about its responsibility.
Meanwhile, I think 2 weeks ago, they eventually came to a decision.
Well, better late than never, but I wish they would have an intelligent case management system that will allow them to adjudicate cases, such that cases are not being robbed of their time value. You know, these cases are time sensitive. If you don't decide it timely enough, then who cares what you say?
So this is just by way of introduction. We'll get into the Nkrumah Nimfa case, but I'm just laying a foundation for this one. The last one that caught my attention was that there was an Asari versus AG in the Amoating case. Which one is that?
This is when Amoating was arrested in the U.S.
Nkoranza?
The Nkoranza, yes, MP. And Parliament gave him a dispensation. They said his excuse for being out of Parliament is reasonable. And I said, how can somebody be in prison in the U.S. and you say he has a reasonable excuse to be out of Parliament? You are basically denying the people of Nkoranza representation. So I went to the High Court, because that's where you enforce this type of cases. And the High Court said it was a political question, so they had no jurisdiction. And then I appealed and won on appeal. So the appeal basically said, look, if a person is out of Parliament, is not able to attend for 15 days, then his seat or her seat becomes automatically vacated. Now, I won that case, but what is happening in the Adwoa Safo case? You know, Adwoa Safo was gone for 1 year, and yet nobody enforced the judgment.
But what I find interesting is that you are an accounting professor. Of course, you're a lawyer now. You live in the U.S., and yet you've done a lot more public policy cases than most lawyers here.
Well, you know, it's a question of interest. You know, I'm very interested in public policy and public litigation.
But you don't teach the law?
I don't teach the law. I teach accounting, yes.
Now, so what do you teach in accounting? Because if the kind of things you are doing, you should be teaching a law class.
Well, you know, accounting is law. Because in accounting, you see, there's somebody who sets standards. Those standards are actually the accounting law. And then people follow that law. People comply with the law. I teach auditing. I teach forensic accounting. Forensic accounting is a branch of accounting that is responsible for finding out who has done what. When things go wrong, how do we figure out who did what? How do we figure out whether there's money laundering and how they are laundering money, whether there's embezzlement and how it's being done. So it is a marriage of accounting, law, evidence, psychology, that type of thing.
Interesting. Wow, it will be interesting in your class. I didn't enjoy my accounting classes, so maybe I'll give it another shot with you. I'm picking your views on general issues before I come to the specific case. So I think one of the big issues now is Frimpong Boateng. I don't know if you've written anything about him. The reason I bring it is that the special prosecutor is sort of trying to deal with the matter. But there's a feeling that in arresting Professor Frimpong Boateng, he sends the wrong signal. Yet I heard the special prosecutor explaining on Newsfile that he feels, look, we cannot fight corruption by saying that some people are saints. So irrespective of what has happened now in terms of the leaked report to the cabinet and all of those things, the process has to be gone through deliberately. All right. But from outside, the optics don't look good. It's like this man has come to blow the whistle. He's released a report that's very damning for high government officials. Special prosecutor is supposed to be an independent body, and special prosecutor is saying, I'm going to question you. And then after questioning the guy, you say, I've arrested you, but I'm going to give you bail. You are the one who's a stickler for the law. I don't know if you've reflected on that case. Where do you sit on this?
Well, I think the problem in that case is transparency. Because while it is correct that nobody is a saint, the public is entitled to know when somebody has been arrested. But you cannot arrest somebody and then the public is in the dark. And then when the public finds out, you then come out to try to explain why you have arrested that person. And it's especially worse when the timing of that arrest coincides with the release of some report that he is accusing some people. Then it looks very messy. And so I think that if the special prosecutor wants to pursue the path that he's on, then he must also be transparent. When he arrests you, you don't arrest someone until you have evidence that they have done something wrong which warrants their arrest. At that point, the public is entitled to know that X, because of Y and Z, is under arrest. The public finds out, then they are entitled to ask, why were you hiding it from us? If you thought arresting the guy made sense and was lawful, why didn't you disclose it? I think that's what the problem is.
But the office itself, if you look at what Martin Amidu said and how he left, and now Kissie Jabing is there, some people feel like, look, having an Attorney General Minister of Justice is the problem. But yes, the President has created his office. Is it doomed to failure in our current political arrangement, or really depends on who occupies the space?
Well, that's a very, very complicated question. I must confess that I was one of those people who was against the creation of the Office of Special Prosecutor because I thought it was redundant, and what we should have done is strengthen the independence of the Director of Public Prosecution. We already have a Director of Public Prosecution who is in charge of criminal prosecution, and that office has to be made independent of the Attorney General. That's the way you solve that problem. But if you create another bureaucracy, and the existing bureaucracy is starved of funds, then I can tell you without knowing more that the new one will also be starved of funds. So what you have then will be two bureaucracies equally starved of funds. And we are going to have the same complaints that we have about the prosecution division of the Attorney General. We are going to export it to the special prosecutor. So I thought the whole thing was not properly conceived and thought through, and it was the typical Ghanaian thing of let's create an office to solve a problem, and then we can check the box and say, well, we've solved the problem. And then we have the hardware, but then there's no software.
This is the point of view. Tonight we're talking to Professor Kwikwa Sari. I don't know what to call him, a legal crusader, public policy crusader. He is actually a fellow of CDD as well, an accounting professor and a lawyer. When we come back, we'll delve into the Assin North case because he's been fighting for dual citizenship rights for, I think, I don't know, almost 30 years. So obviously he's very interested in the case. What does he make of how the case ended? We'll be right back. Stay with us.
Finally, anyone can become a household.
Oh, wow.
Yeah. You Go Flip, a real estate gaming platform that allows you to play and stand a chance of winning a house or cash or consolidated prizes, such as savings towards a house. Simple and easy to play. Visit www.yougoflip.com. Buy a ticket to enter the game. Wait for the end of the game to enjoy the win. Anyone can win. Flip it or own it. You Go Flip. This advertisement has been vetted and approved by the Gaming Commission of Ghana. Play responsibly, not for persons below 18 years, and gaming can be addictive.
Come back. The point of view tonight is talking to Professor Kwekwa Sari, who has been campaigning on legal issues in Ghana for almost 30 years. Tonight we're going to talk about the Assin North case. I need to mention that there is an effort in Parliament to repeal Article 94(2)A and obviously 8(2), and obviously all the things that they are concomitant stuff, which I believe you support.
I support
you support
it,
the
yes,
principle.
yes.
And also you did say that Act 527, you were part of the team that came in to say do our citizens have rights. So this case must have been very important to you.
Absolutely.
So what do you make of the judgment?
Well, first, let's get it clear that we have one Supreme Court, and when they speak, they have the final word. That's why they are supreme. But merely because they have the final word doesn't mean they are infallible. Often courts get it wrong. Mm-hmm. So, for instance, we know in the US, there was actually a court, the Dred Scott Court, as well as the Plessy Court, that basically said, look, Negroes are not even 100% humans, and then you can have a system which tolerates what they call separate but equal. We can put whites in a separate place and blacks in a separate place, but we are equal. These are examples of cases where the Supreme Court speaks, but then the Supreme Court gets it wrong. Back home, we've had the Ria Kutu case. I think that's the first case every student is made to read in law school, and they got it wrong. Of all the Ghanaian cases that I've seen, including even the Asari case in 2020, where the Supreme Court said it lacked jurisdiction. I mean, that's a weird decision. This one stands out as almost the worst, because when you read the case, the plethora of errors, from misapplying misinterpreting the Constitution, to shredding statutes, to inserting timelines where there are no timelines. It's almost as if the court decided we are going to remove this guy for whatever reason, and we don't care how many laws we break or how many rules we violate, we're going to do it anyway.
Are you serious? Because I read I'm not a lawyer, but I read the judgment, and it seemed reasonable to me on the basis that I think my understanding what they were saying was that, look, you filed your papers to be MP between 5th and 9th October. At the time you filed your papers, you hadn't received the certificate of renunciation of your Canadian citizenship. So that's point number one. Point number two, there was a prior case, Zaneto, ex-party they call it, where somebody assessed Zaneto was not qualified to be MP because as of the time NDC had chosen her as the candidate for Clote Colley, she did not have a voter card. And then the court, Zaneto went to court, and the court said, look, she hasn't filed. The process has not started, right? So the court is saying that, well, if you use Zaneto, it means that the time to check eligibility is when the filing is done. So they interpret that to say that the filing period was October 5th to 9th. That's number one. Number two, you are a citizen of Canada. So Article 494(2) is basically saying that if you owe allegiance to another country other than Ghana, you are disqualified. So they put 1 and 2 together and say, as of the time Mr. Jachikwesin filed, he hadn't received the certificate. So he was still technically a Canadian citizen and he used to be a Ghanaian. And then they said that means that his allegiance is questionable because allegiance and citizenship are inextricably tied. So for me, who didn't go to law school, okay.
Yeah, it's almost like me coming here and saying, look, allegiance and citizenship are inextricably tied. So when the president swears the oath of allegiance, he's swearing the oath of citizenship. That is completely bizarre. I've never seen such strange reasoning. One can owe allegiance to a country for a variety of reasons. Citizenship is only one of them. People who are not citizens owe allegiance to the country because they must follow the rules, the government must protect them. We call that local allegiance. When the president swears the oath of allegiance, he's swearing an occupation-related allegiance. Article 94 2A predates Act 527. In other words, when the Constitution was initially promulgated, we had this allegiance article, but dual citizenship was not even allowed. Is the court saying that Article 94 2A was put there in anticipation of a time when dual citizenship will be allowed, and then they'll come out and tell us that they are interwoven, and therefore citizenship means allegiance? I mean, it's so bizarre. I mean, look, if you read the law and you find an article saying a citizen who is a citizen of another country cannot do X, and you read another article which says a person who owes allegiance to a country other than Ghana can't do Y, the mere fact that the legislator or the constitutional framer has used different terms should tell you that he's referring to different things. Otherwise, he would simply have said a person who owes allegiance to a country or a person who owes allegiance to Ghana can also owe allegiance to another country when we amended the Constitution.
Okay.
But they chose to use citizen for a reason. So a citizen, by definition, owes allegiance to a country. But it doesn't mean that Article 94 2A is talking about citizenship. And the sad thing for me is in the case that you are referring to, the court actually cites an Australian case. And they cite Section 44(1) of the Australian Constitution. And Section 44(1) of the Australian Constitution says a person can be disqualified if 1, he owes allegiance, or 2, he's a dual citizen. But that tells you owing allegiance is a separate ground for disqualification, and dual citizenship is another separate ground for disqualification.
In the Australian case?
In Australian case. In the Ghana case, we only have the allegiance wing because dual citizenship was not even allowed. So allegiance has nothing. Allegiance in Article 94 2A has nothing.
Well, my understanding what they said was that allegiance as a general term is subjective. And they cannot tell whether Kweku Azan or Bernard Avile has allegiance in their mind. But there must be an objective way of proving it. So whilst what you're saying could be true in general allegiance, let me explain. What they're saying is that to prove allegiance objectively, the only way to do that is citizenship.
Yeah, I mean...
That's what they said.
Yes, because if you start by assuming that allegiance is citizenship, then you are going to continue by saying the only objective way to prove allegiance is citizenship. By the way, that is false.
But they also said that, you referred to the fact that 94 2A was there before the amendment that brought in amendment of Article 8. They did quote that on page 30 where they were talking about Act 527 and said that when the issue, let me just read that for your comment. So it says, with Act 527, the sharpness of the original aberration against dual citizenship was blunted by the provision of the new Article 8, admitting dual citizenship. But in this exercise, the amendment was clear to determine categories of national functionaries who cannot owe allegiance to another country or put simply, cannot hold dual citizenship. So again, they make the two similar. Let me read the final sentence. They are listed in Section 1 of Act 527. Article 8 and Act 527 then carefully recognize that in its operation was without prejudice to Article 942, meaning that the edict against MPs owing allegiance to another country was unaffected in the amendment of Article 8.
Yeah, that's, again, complete misunderstanding. Because what they are continuing is just saying that a citizen has allegiance. That is strike law. Nobody who is serious would argue whether or not citizens owe allegiance. Citizens owe allegiance. That is not what the court has been called on to interpret. The court is called on to interpret what allegiance means in Article 94(2)(a). And the starting point is to understand that it can't be about citizenship, because Article 94(2)(a) predates dual citizenship. Second, I cited the Australia case, where they distinguish between citizenship and allegiance. And by the way, if you go to the Nigeria Constitution or the Sierra Leone Constitution, you can see the same disjunctive use of citizenship and allegiance. Let's be clear what allegiance means. This whole Article 94(2), and Article 94(2) is different from Article 94(1). The Zanito case, will come to that.
Yes.
This whole Article 94(2) disqualifies people, and not just from becoming MP, but also from becoming the member of the executive, from belonging to any of the constitutional bodies like the Electoral Commission, the National Civil Commission on Civic Education, the Public Service Commission. It disqualifies people from being leaders of a political party, founders of the political party, or executive members of the political party. So what type of activity can one engage in to be stripped of these basic rights? You have to look at Article 94(2) in totality to even understand the type of things that are being targeted. Serious moral failings and offenses against the state. If you read that, they say somebody who has been adjudicated to be a bankrupt or a criminal lunatic, somebody who has been convicted of treason, high crimes, somebody who has been sentenced to death, or
offense punishable by death,
yeah,
relating to connected to election under a law in force of Ghana at any time. So you're saying that the kinds of things that
Yes.
prescribe a person
Yes.
from being qualified are too serious
Not only-
to put in the same category as dual citizenship.
not only are they serious, it's not just one of these things that you can come and say, oh, I've renounced, then they say you are qualified. Look at 94(5). If you look at 94(5),
94(5) says a person shall not be taken to be disqualified to be a member of parliament unless under paragraph C or D of clause 2 of this article, if 10 years or more have passed since the end of the sentence of the date.
So,
wow.
So the Constitution itself
Or has been
tells
pardoned.
you how you purge yourself
Of those levels
of those levels of violations before you can even be admitted into the political community. Article 94(2) was not something that, oh, I'm a citizen.
So let me ask you, so your view is that Article 94(2)(a), what does this owe allegiance to a country mean? Because it was not explained in the Constitution. And I feel this is what happens. And again, and not to hold brief, but what they tried to do was to cite Atuguba, in your case, reading portions of the report of the CRC, because I think what you people say in law is that when we don't have the interpretation here, we go to what the original, those who framed the Constitution, what they were trying to say, right? So because this Constitution does not define allegiance, they sort of went into, and in that case, by the way, Atuguba was not the only person. It was a Supreme Court case, so there was also Dateba and a few others, right?
Yeah, but Dateba was the main opinion, and in fact, I'm trying to.
So you are saying that the Atuguba they even cited in reading the report of the CRC of the Constitution Committee was not necessary. Was not what they should have read.
No, because Atuguba is a concurring opinion. The court opinion in Asai 2012 was written by Dateba. And he emphasized things like what political rights are and so on. That was the argument. Atuguba was quoting the Bible and saying the Bible says. I mean, I'm not going to.
But that was a concurring opinion.
Yeah, that's what I'm saying.
So it's in line with what Dateban supported.
No.
Because they were on the same side.
They were on the same side, but you can be on the same side
but
for
have a different reason.
Yes, for different reasons.
But they chose to use that.
That's why, if you look at the other judges, they will say, "I agree with my brother Dateban." Well, that means they don't agree with their brother Atuguba. I agree with my brother Dateban. That means now you say the meaning of allegiance is not in the Constitution. I disagree.
Okay.
Because you see, people read the Constitution and then they try to interpret the Constitution by going to a dictionary. They say the Black Lord. No, this is the Constitution of Ghana. You have to go to the legislative history. And I have here from the 1969 Constituent Assembly, the memorandum accompanying their work. And they explain this thing. They say, we have recommended that members of the police or prison service or the armed forces and a person who has made a declaration of allegiance to a country other than Ghana. So this is right here. And they explain the reason we want to exclude these people is because of the natural incompatibility of their occupation. So the allegiance there is an occupational related allegiance to another country.
What about the last line you read? A person who has made a declaration of allegiance to another country.
To a country other than Ghana. Yes.
Is that declaration not... Does that declaration not happen during citizenship?
No. I mean, that it can happen.
So I'm trying to understand.
Yes,
So the person is Ghanaian by birth.
Yes.
But then for occupational reasons, he goes to Canada to
Yes,
work. And
yes.
then he declares
Yes.
in this
Yes,
accepting
yes,
Canadian
yes.
citizenship, that declaration of allegiance.
But it would be wrong to assume that because they are not talking about citizenship. Even though citizens can owe allegiance.
So how would that person so that declaration of allegiance will be what?
Well, let's say
You can only declare allegiance in a verifiable way in a citizenship context.
No.
Or unless you are taking a position in that country. So put two things. Using this case again, what you just read in the 69, he will either declare the allegiance to be a citizen of that country or to take a position which is sensitive in that country.
Precisely. To take a sensitive position. That's what they are targeting. So, for instance, when the president takes the oath of allegiance, he's taking the oath not of citizenship, but of the job that he's about to take. If you are a Ghanaian who is permanent resident in the U.S., for instance, you are not a citizen of the U.S., you can join the army.
Okay.
When you join the army, you take the oath of allegiance. If you practice...
So you don't need to be a U.S. citizen to fight in the U.S. Army?
To fight in the U.S.
But
Army.
you can take the U.S., you can take an oath
Absolutely.
to defend the U.S. flag in war.
Not just that, oath of allegiance. And you say...
So you think this is what they were contemplating?
Not only this is what they were contemplating, there was a reason. If you go to 85 or so, there was a swap of a Ghanaian who was dating a CIA woman and extracting information from the CIA woman. And when Susudis, his name was Susudis, when he was arrested in the US,
yes, I saw that.
There was a swap. The people who were swapped from Ghana were Ghanaians. They were not dual citizens. They were single citizens. But they were described as CIA assets. This is the type of problem that Article 94(2)A is targeting. Someone who is basically a traitor who joins a foreign army to fight against Ghana.
In espionage, in this case.
In espionage. In the UK, for instance, they recently prosecuted a case like that, where UK citizens had gone to fight for ISIS.
Yes.
Or even in the Ukrainian...
I think there was a young lady as well, and I think that this discussion was around whether her citizenship could be revoked. And I think the House of Lords said no.
Precisely.
Citizenship is not revocable.
Precisely.
You can say she's not entitled to some rights.
Precisely.
But being British was a natural by birth.
Precisely.
Yes.
Or in the Ukrainian war, some Russians are fighting for Ukraine, and then Russia would say, look, you owe allegiance to Ukraine because you joined the army and you are fighting us. That is the type of thing that Article 94(2)A is targeting. And that's why I'm saying Article 94(2)A contemplates the most egregious violation of law of betraying the country. And it's not something that you can willy-nilly say, oh, today I've declared my allegiance And so,
but just a question: if dual citizens by our constitution cannot be president, cannot be vice president, cannot be chief justice, is it not reasonable to say that that is the same flow of thought that affects MPs?
no, because again, go to Article 82. It says, without prejudice to Article 94 2A, and again they misinterpret that. What the without prejudice is saying is, if you are a dual citizen, you cannot hold these positions merely because you are a dual citizen. But in addition, if you owe allegiance to a country other than Ghana, as described in Article 94 2A, then you'll be disqualified from those other positions that are disqualifying under Article 94 2A. So everybody is going to be held under Article 94 2A for owing allegiance. And then in addition, dual citizens are going to be excluded from these positions that are specified by Article 82. That is what without prejudice means. It doesn't mean whatever Justice Amegache was saying. No, it doesn't mean that. Without prejudice means the position that you have been excluded from here does not prejudice whatever positions that you are going to be excluded under Article 94.
I'll take another break. When I come back, I want you to address the issue of the certificate not having been given or not having arrived at the time. The fact that the EC chose or failed not to defend itself, and then also the role of the Supreme Court now asking for an expulsion of his name or expunging his name from the record. This is the point of view. We're talking to Professor Kweku Sari. We'll be right back. Stay with us.
Pepsodent introduces charcoal and lemon essence. The unique combination of natural essences whitens teeth naturally for you and family, because every smile matters.
New Pepsodent Herbal. Introducing a unique combination of herbal extracts in an antibacterial toothpaste for strong teeth and healthy gums that protects your family and you. Every smile matters.
Come back. We're talking to Professor Kweku Sari. So one of the things you took issue with was the usage of the Zaneto matter, because according to the court, the Zaneto was very clear on when eligibility should be construed or the time frame. You disagree?
100% disagree. And again, I'm afraid the court does not understand the difference between Article 94.1 and Article 94.2. Now, if you read Article 94.1 and 94.2 quickly, you might think they are saying the same thing. But they are saying different things. And if you can,
I'll put it up. So
if you can show your audience.
94.1 says qualifications and eligibility. 94.1. Subject to the provisions of this article, a person shall not be qualified to be a member of parliament unless.
Underline that unless.
And then there's a dash. A, is citizen of Ghana, has attained age 21 and registered voter. B, resident in the constituency for which he stands as candidate for election of parliament or has resided there for a total period of not less than 5 years out of the 10 immediately preceding to the election for which he stands or hails from the constituency. C, has paid all his taxes or made arrangements, blah, 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 blah. Now, 94.2, a person shall not be qualified to be a member of parliament if he, so I underline if.
Yes.
And then again, owes allegiance to a country, that's A, other than Ghana. B, has been adjudged to have done the things you just listed. So you are saying that 94.1 is unless, 94.2 is if.
Yes.
And that means what?
That unless means you are not eligible, right? It's an eligibility requirement. If you are not a citizen of Ghana, if you are not 21, if you don't whatever, then you are not even eligible.
So it's a non-starter.
It's a non-starter. You can't even pick up forms.
Wonderful. But 2 is saying
two has no time dimension. 2 is saying a person who is eligible and has even won will be disqualified if any of these things happen.
So these are now conditions.
This basically says if today we find that an MP owes allegiance properly interpreted, or is adjudged to be bankrupt,
or criminal,
or is a criminal lunatic, he would be disqualified from his
Even
position.
though he won?
Even though he's won, and even though he's in parliament for 3 years. Because it's the disqualification that has no time dimension. That's why it says, it doesn't use the word unless. It says you are not qualified if you do these things. If you do these things, then an easier way for them to have stated that would have been a person would be disqualified from parliament if any of these things happened. And that is the distinction between eligibility and disqualification. And that's why Zanetor does not apply to Article 94.2. And you can see that the people who drafted the PNDC Law 284, they know the difference. Because if you read PNDC Law 284, Section 9.1, and compare it to Section 9.2, you see the difference. Section 9.1 talks about you will not be allowed to pick up your forms if you are not a Ghanaian and so on. But Section 9.2 says you cannot be eligible, you cannot be qualified to be in parliament if
then they list those
things. So 94.1 and 94.2 are totally different articles. One is dealing with eligibility, and that eligibility is tested when you go to pick up your forms. 2 is dealing with disqualification. You can be disqualified.
Yeah, I understand that, but I think the point they were making was that even though those distinctions are important, the principle of the time was what they were discussing. That the principle is that the time for determining eligibility is a specific period. You are saying that because of the word if, there's no concept of time in 2.
Not only is there, it's very obvious. Number 2, the only power in Ghana who decides time is the Electoral Commission, not the Supreme Court. The Supreme Court has no power. It has no expertise in deciding when these things should be decided.
But the Electoral Commission chose not to defend itself.
Well, that again shows you that there's something wrong. Because why did the Electoral Commission allow Kwesi to contest?
Because they were convinced that by the time the election will be held, he will have the certificate.
Not only that, because they were following the law.
Based on their understanding.
Not just their understanding. Section 9.2 basically tells us. And the Electoral Commission basically should have gone to court and said, look, the law is, if the person is in parliament, then basically, yes, allegiance. But this is a guy who showed us the certificate of renunciation.
Before the election itself.
Even before the elections.
And so just for the mere fact that at the time that he submitted his papers, he didn't have the certificate, he's been disqualified.
Yeah, and then they cite the Australian case to support that. But the Australian case was dealing with dual citizenship. Ours was dealing with allegiance. I submit that in the case of allegiance, it's not something that you can just renounce and take. No.
Do you think they should have gone to Canadian law in this matter?
Absolutely. This is what I call the Amasewa principle. The Amasewa principle, which basically was recently enunciated by my good friend Yoni Justice Kulendi, is basically saying foreign law is a matter of fact in Ghana. So if you read the Jomoro, Jomoro had a similar problem. Yes. They brought an expert witness from Ivory Coast
to explain the position of Ivorian law.
To explain the position of Ivorian law.
And that's still the case.
You cannot sit there and then just assume as a matter of law that somebody owes allegiance to Canada. Based on what? And yes, another funny thing.
But they did cite a Canadian law where they said, I think they said a certificate had not been issued, so that if you can on your own suo motu initiate a process of renunciation and there is no confirmation from the other side.
Yeah, that's all.
It's reasonable, right?
No, it's not.
Because if I say I want to be a citizen of the country and I apply, I need a certificate to prove that I've been given. So the opposition should hold when I'm renouncing.
In Canada, there's actually a case on point. It's called Makatia. There were a couple of people who said, look, they don't want to owe allegiance to the Queen. And when they become citizens, they swear that oath. The court said, look, swear the oath, get your citizenship, and after that, disavow allegiance. Allegiance, we don't care about allegiance, but if you want to be a citizen, you just swear the oath. Whether you want to continue to owe allegiance, it's subjective. It's up to you. And so there's actually a website. It's called disavowal.ca. If you go there, you see a whole bunch of Canadians who are saying they don't owe allegiance to Canada. I mean, if the court is serious, this is a case that they should cite. But the bigger problem is that the allegiance that I'm talking about, that Article 94.2 is talking about, is not a variety of these things that you can just go and say, tomorrow I take my citizen, tomorrow. No. that is a fundamental misunderstanding. And one has to read Article 94 holistically to even see why something that is lawful, because dual citizenship is a lawful status. Why would you put a lawful status with things like criminal lunacy?
Will this be solved if the people in Parliament who want to expunge 94(2)(a) and 8(2) succeed? That would solve this matter.
Yeah, I mean, I analogize that to the repeal of the criminal libel law, because the Supreme Court, again, in the libel cases, they were putting newspaper editors in prison.
I know criminal libel.
Well, not but the people, they were actually putting people in prison. Kokuba and so on, until Kufuor and Co repealed it. And that's what I think should happen here. We repeal.
Do you think it will succeed?
I think it will succeed, because basically...
Don't you think that Assin North has tainted it?
No, I think...
Or the timing is not right?
No, I think Assin North basically has reminded all of us that, look, what are we doing to ourselves? Here is a guy, Ghana has invested so much in him. Ghana has invested so much in all these people who go abroad and acquire citizenship. And instead of us to leverage their skills like we do when we are composing the Black Stars, why are we saying that they can't be this and they can't be that? Why don't we disqualify them from becoming professors and from becoming... I mean, what is so special about these positions that we are trying
to... Because that's where the meat is.
Right?
We'll leave it here. Prof, look, we have a lot to talk about. Thank you for coming through. I hope you stay a bit longer in Ghana so we can talk again soon. I'm speaking to Professor Kweku Asare, who is known on social media as Kweku Azan. He's not an Azan guy. He's been talking to us on very many legal issues, particularly the Asin North case. We'll see you next time. Thanks for watching. Bye-bye.
The Point of View is brought to you by Belpac. Belpac, just perfect.
Hello and welcome to City Sports Roundup with me, Benjamin Nketia. Coming up, Black Stars head coach Chris Hughton explains decision to withdraw injured Gideon Mensah from squad for Madagascar game. Also, Black Meteors to play defending champions Egypt in a friendly match on Thursday ahead of Under-23 AFCON in Morocco. And Real Madrid complete signing of Jude Bellingham from Borussia Dortmund on a 6-year deal. Let's get to the details of our stories now. Now, head coach of Ghana's Black Stars, Chris Hughton, says Gideon Mensah's involvement in Auxerre's relegation battle in the French Ligue 1 has played a big role in his injury absence. The 24-year-old who arrived in camp on Monday has been ruled out of Ghana's AFCON qualifier against Madagascar on June 18 due to a knee injury. Speaking ahead of the game, Hughton says the decision to withdraw Gideon Mensah from the squad was a bid to avoid aggravating the injury.
The situation with Gideon is that Gideon his club have been managing an injury that he has. But this is somebody that's been playing in all of the games, and maybe some of that is because his team were obviously in a very difficult position. Sometimes you get a feel from a player who is maybe not so confident in coming, or a player who wants to come. You know, Gideon wanted to be here, and that's a good sign, and that goes back to the first question. You know, this is somebody that wanted to be here in camp. So it was our responsibility to assess him, to assess where he is at the moment with the medical information, and come to a conclusion. And the conclusion is that probably at this stage, we didn't want to risk him. You know, this is post-season. He has as with all of the players, they have a pre-season to go back to and the start of another season, and we felt it wasn't right to risk it. The second part of that is that at this moment we haven't brought a replacement in. We will work how we will work this week. If we feel different, after these few days, then we'll assess that again, and perhaps somebody that will be in a standby situation. But at this moment, we are not bringing in a replacement.
Still on Black Stars head coach Chris Hughton, he believes it is his responsibility to know the Ghana Premier League and the players who play in the competition better. He made these comments while addressing the inclusion of Bechem United striker Hafiz Konkoni to the Black Stars squad.
It's really only today that we've seen him. Yes, because he played on Sunday. Yesterday he had a recovery day, so he trained today. And probably what I was fortunate to see him live at last weekend, and I have been able to watch him on video, and so that it wasn't